Hi friends, this is me Cleta Laurencio, and today's topic, what I am going to deal about, is the powers of the court. Now let us know the synopsis of it. Court, by which the offence is trialable. Second, jurisdiction in the case of juveniles. Third, sentences which the High Court and Session judges may pass. Fourth, sentences which the magistrate may pass. Fifth, sentences of imprisonment in default of fine. Sixth, sentences in the case of conviction of several offences at one trial. Seventh, modes of conferring powers. Eighth, powers of officers appointed. Ninth, withdrawal of the power. And tenth, power of the judges and the magistrate. Section 26 in the Code of Criminal Procedure. Now the first synopsis what I am going to deal with. Now section 26 which talks about code by which offences are trialable subject to other provision of this code. Now here any offences under Indian Penal Code 45 of 1816 may be tried by the High Court or the Court of Session, any other court by which such offence is shown in the first schedule to be trialable. Any offence under any other law shall, when any court is mentioned in his behalf in such law, be tried by such court, and when no court is so mentioned may be tried by the High Court or any other court by which such offence is shown in the first schedule to be trialable. Now the first case is Buddha Chaudhary 1955 SCR 1045 and 1050. So here it was argued before the court that a magistrate under section 30 is enjoined by to try the case before him as a magistrate, and accordingly he shall follow the warrant procedure, which is different from the procedure followed by a court of session. In a court of session, the accused was entitled to the benefit of commitment proceedings before the magistrate and a trialable before the session judge with the aid of the jury or assessor. But this was denied under section 30, and thus it was violative of Article 14, as there was an infraction of fundamental right of equality in such cases, and b. The provision was liable to abuse the discriminated between person of accused of offence of same kind, as the police had discretion of sending a person accused of an offence under a particular section to a section 30 magistrate or send another person accused of the same offence under same section to a magistrate who could commit the accused to the court of session. Now here, the judgment was the Apex Court held section 30 of CRPC did not violate the right to equality guaranteed by the Article 14 of the Constitution of India. Now, subject to other provision. Sabri Ali 1964 7 SCR. Now here the word subject to other provision of the court in relation to section 26B have been interpreted by Hidayatullah. Now here he says that the words are peremptory. There is no escape from them. They say that is subject to other provision of the court, any offence under any other law shall be tried in the court when such court is mentioned in that law. Powers of the Court of Session. Now here, section 26, where it gives powers to High Court and the Court of Session to try an offence under the Penal Code even though it is trialable by magistrate, according to the sixth column of the first schedule of the court. Offence within and beyond the jurisdiction. The jurisdiction of every criminal court to try an offence is derived from the statute. Now here the case is Jankar Abir 46 CR LJ 399 403 FB. Now, the consent of the parties cannot vest the jurisdiction in any court. So here it says that the consent of the parties is not required to vest in the jurisdiction of any court. Now, what are the jurisdiction? Jurisdiction is an area of the court. Section 27, Jurisdiction of the case of juveniles. Section 27 in the Code of Criminal Procedure, 1973. Jurisdiction in case of juveniles. Any offence is not punishable with death or imprisonment for life committed by any person who are, at the date when he appears or is brought before the court under the age of 16 years, may be tried by the court of a judicial magistrate or by court especially empowered under Children's Act 1960, 60 of 1960, or any other law for the time being in force providing for the treatment, training, rehabilitation or youthful offender. So here this is about the juveniles. So people here, the person who has committed a crime and what in a jurisdiction in the case of a juveniles. So they are considered to be as a youthful offender. So it is basically deals about the rehabilitation or about your training and treatment. Now what are the scope of this section 27? Now this section speaks about the offences other than those punishable with death or imprisonment for life. Now here the case is Govind Chandra 1977 CRLJ 1 499 FB, where the person is juvenile, where they have to be raised by magistrate before whom such juvenile is brought. But if no such point was taken and the magistrate took such cognizance and committed him to the court of the session and the session judge already assumed the jurisdiction, no such objective could be raised either before the session judge or the high court in the revision. Section 28 in the Code of Criminal Procedure 1973. Section 28. Sentence which High Court and Session judges may pass. A High Court may pass any sentence authorized by law. A Session Judge or an Additional Session Judge may pass any sentence authorized by law, but any sentence of death passed by any such judge shall be subject to confirmation by the High Court. An Assistant Session Judge may pass any sentence authorized by law except a sentence of death or imprisonment for life of imprisonment for a term exceeding 10 years. Now, sentencing principle. Section 28. Here, where the maximum and minimum sentence are being prescribed, both are impossible depending on the facts of the case. It is for a count after recording the conviction to be imposed the appreciate sentence. It is therefore cannot be accepted that minimum sentence is impossible and not a maximum sentence merely because minimum sentence that is provided that does not mean sentence is impossible. Is only for maximum sentence. Relevant consideration of the sentence include motive of the offense, magnitude of offense, character and the manner of its commission. Now, Section 29 in the Code of Criminal Procedure 1973. Now here is a sentences which magistrate may pass. Now, the Court of Chief Judicial Magistrate may pass any sentence authorized by law except a sentence of death of imprisonment for life or imprisonment for a term exceeding 7 years. The Court of Magistrate of the first class may pass a sentence of imprisonment for a term not exceeding 3 years or of a fine not exceeding 5,000 rupees or both. Now here, the Court of Magistrate of second class may pass a sentence of imprisonment for a term exceeding 1 year or for a fine not exceeding 1,000 rupees or of both. Now Court of Chief Metropolitan Magistrate shall have power of the Court of a Chief Judicial Magistrate and Metropolitan Magistrate, the power of Court Magistrate for the first class. Accused undergoing imprisonment in default of payment of the fine. Section 68 of Indian Penal Code indicates that imprisonment which imposed in the default of payment of a fine shall terminate whenever that fine is either paid or levied by the process of law. Now here there is nothing in the code which is provided that undergoing the whole period imprisonment the fine shall not be recoverable. Now here the section 30 in the Code of Criminal Procedure 1973. Now here it is the sentence of imprisonment in default of fine. The court of magistrate may award such term of imprisonment in default of payment of fine as it is authorized by law, provided that the term is not excess of the power of magistrate under section 29. Shall not, where imprisonment has been awarded as a part of a substantive sentence, exceed one-fourth of the term of imprisonment which a magistrate is compelled to inflict as a punishment for offence otherwise than as an imprisonment in default payment of fine. The imprisonment awarded under this section may be addition to substantive sentences of imprisonment for maximum term awarded by the magistrate under section 29. Scope of law. Where the sentences of imprisonment and fine, section 30 should be read with section 64 and 65 of IPC. Imprisonment in default of fine is in punishment not for the offence committed but a penalty for the failure of accused to pay the fine ordered by the court and can be avoided by paying the fine. Imprisonment in default of payment of fine. Now here, the clause A of proviso applies when sentence is one of the fine only, and in such case where the magistrate may award the imprisonment only in default of fine up to the limit of his power. Section 31 in the Code of Criminal Procedure 1973. Now sentences in case of conviction of several offences at one trial. When a person is convicted at one trial of two or more offences, the court may subject to provision of section 71 of Indian Penal Code 45 of 1860. Sentence him to such offence to several punishment prescribed therefore which such court is competent to inflict such punishment while consisting of imprisonment to commence one after. The expiration of other in such order as the court may direct unless the court directs that such punishment shall run concurrently. In the case of consecutive sentences, it shall not be necessary for the court by the reason only for aggregated punishment for several offences being in excess of punishment which is competent to inflict on the conviction of single offence to send the offender for a trial before High Court, provided that in no case shall such person be sentenced to imprisonment for a longer period than 14 years. The aggregate punishment shall not exceed twice the amount of the punishment which the court is competent to inflict for a single offence. For the purpose of appeal by a convicted person, the aggregate consecutive sentence passed against him under section shall be deemed to be single sentence. Now, scope and application. Now, section 31 applies to conviction of offence. It does not apply to imprisonment of offence under section 122. Therefore, it is illegal for a magistrate to direct under this section the sentence of an imprisonment for an offence should take effect after expiry of the sentence which accused may be going for a default for furnishing security for good behavior. Now, section 32 in the Code of Criminal Procedure 1973. Modes of conferring power. In conferring power under this code, the High Court or the state government, as the case may be, by order empowered a person especially by name or virtue of the offices or classes of officials generally by the official titles. Every such order shall take effect from the date on which it is communicated to persons so empowered. Scope. Mahadeva All India Report 1970-52. Powers may be conferred generally or specially. It is generally when conferred on the class of official title. Thus, a magistrate of a first class or second class may exercise the power. Thank you everyone. Please do like, share and subscribe to my video channel. Thank you.